Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries. My name's Tony Carbone. I'm a personal injury lawyer of over 25 years' experience. With me tonight, I've got John Carancis, an expert in work cover law. Good evening, John.
Hi, Tony. Hi, viewers.
And Don Maffia, a Transport Accident Commission partner in a law firm. Good evening, Don.
Good evening, Tony. Good evening, viewers.
Viewers, tonight we've got Dr. Nathan Serry. He's going to be talking about the tough changes to transport accident law, so please stay tuned for that.
However, Tony, what's in the news?
John, there's been a lot of stories, but the one that keeps cropping up is this no compo for rough sex on the job.
Oh, yes.
What's that about, John?
Oh, yes, Tony. The question the High Court had to deal with was, when is sex on the job not on the job?
But it wasn't part of her job. We think it wasn't that she was going to a retreat or something, and it was after in a motel room.
We've got to let the viewers know what some of the facts
Viewers,
are.
This is a lady that was on a work trip in New South Wales over the weekend. She met up with a friend of hers, and during
outside of work, she wasn't working, was she?
No.
Well, on a Saturday night during rough sex, she gets injured.
Up until the High Court, viewers, she was entitled to compensation because she'd gone before the federal court, the full federal court.
Yes.
Got to the High Court and she was knocked out 4-2.
Exactly, Tony. The High Court said, using previous precedents, that in this instance, the employer could not reasonably foresee that these were part of her work duties and therefore it's not a work-related injury.
But John, it wasn't the actual act of sex that caused the injury. It was the light fitting fell off the wall.
Oh, we forgot about that, didn't we? Yes.
So the light fitting fell on her head or something. So it was during the act.
During the act.
Like I said, just to clarify, it wasn't during the course of the, let's say, for example, the conference or whatever she was at. It was after it finished in a motel room.
Well, basically what I was saying, there was a break in the chain of causation. That is
Exactly.
that the act of having sex wasn't part of her job.
Exactly.
Yeah. Now let's keep moving.
Exactly.
Cyber bullies face time in prison. This is a new law that you're going to introduce in New Zealand, Don. Tell us a bit about it.
Well, if you've got cyberbullying, so if you've got intent, someone does an intent to cause harm, so sends a tweet or sends Facebook messages, something like that, with an intent to cause harm, it can be a criminal offence under New Zealand laws, Tony.
John, do you need to prove the intention, or is it just the fact that you've got it on the video sufficient?
Well, in my view, that would be sufficient. However, as we understand, criminal laws, usually it's a higher test, Tony.
Well, what about the fact that here, an example given is that this group of guys called Roast Busters having sex with drunk girls, many of them underage, and posting details, including the girls' names, online.
Well,
would that suffice?
Well, yes, and underage also, that's a criminal offence in any event.
Yeah, it is. Yeah. It is.
And there's also power to, or it's called a takedown order, seek a takedown order. So let's say, for example, schools are aware of this bullying. They contact the Facebooks or your Twitters and say, we want this, get an order to take down whatever was posted.
Well, why isn't Twitter and Facebook liable for the actions of people like that?
Oh, Tony, it's a long straw there. Well, firstly, you've got foreseeability. Twitter and Google are only a facility for people to lodge information on.
Yeah, but there can't be a facility to do whatever you want.
Exactly.
Yeah. It's got to have some sort
I
of
think it'll be very difficult to monitor. The number of users, if you look at
we should take this up in another
users.
episode, I think, don't you?
And also, in the sense, who do you sue in Google? Someone in California?
Now, this is one that's really close to our hearts, especially Don, because, he's a TOC lawyer. Drivers that are driving along and taking pictures of themselves and posting them. Yeah. Can you believe that one, Don?
Yes, that's on Instagram or the Facebook, taking selfies whilst they're driving.
Is this another Generation Y
Yes, John, it looks like it.
event?
So this is the selfies is becoming a phenomenon across the world. Everyone,
I'll tell you an interesting statistic. Researchers said that a driver who took their eyes off the road for just 2 seconds of 50 Ks would be travelling blind for 27 metres.
Unbelievable.
That is really,
well,
really
Dane, it's just
dangerous,
another.
isn't it?
Dangerous.
It's another example of driver distraction. Taking these selfies is just blatant.
And what
Take
there
your
wa-
eyes off the road.
And there was one example of a lady taking a selfie whilst eating a hot dog.
Yep, hot food. And another lady that she's leaving a funeral in a car, and she took a selfie.
Now
leaving
these
the funeral. So
these
are-
people understand that they are actually posting evidence whereby the police can prosecute them for a criminal offence.
Yep. Well, look, in this day of social media,
Yeah.
social media is being used constantly we're finding against our clients.
Oh yes.
So there
Facebook.
you go. It's there. It's evidence.
Evidence in Facebook, Tony, in a work cover conference just recently, the work cover defendant lawyers produced to me the printout of every Facebook item on my client's Facebook page, showing her having a great time, partying away, doing a lot of things which she said that she couldn't do.
Okay, contradicting her injury.
It's literally, once you put it out there, it's in the public domain. You put it online, you've got no control over it.
Exactly.
Let's keep moving. There was, in Queensland, a judge upheld a will that was typed up on an iPhone.
Yep.
But where's the usual witness signatures? That's
The attestation clause, Tony, the witnessing, it's very odd, isn't it, Tony? But
Well,
is this
it is
a sign
movement
of the
with-
times?
Yeah, it's moving with the times. I think, these days everything's electronic. We have to allow for these things to happen. And in this case, it was...
But do
you
we?
put it in the
But
iPhone.
really, do we?
Well, how is she going to control it, John? I mean, this is a world where every day there's new apps coming up, there's new technologies, there's Instagrams, Google, the whole lot. We have to move with the times. I mean, those days of signing a piece of paper, one day they'll be gone. So,
Well, this guy committed suicide shortly after he did his will. That's extraordinary, really, isn't it?
Yeah. Yeah.
no, I think that's just one of many examples going to come through, given how...
Viewers, don't do it on your phone. Go and seek legal opinion, because there's a lot of reasons why wills won't be upheld these days.
Exactly.
If you haven't done it properly, if you haven't provided for certain people. This is what our story's about tonight. The changes to the TAC laws, which are probably the most toughest ones I've seen in many, many years. And we're fortunate to have Dr. Nathan Serry coming on just after the break.
Tony,
So-
the state Liberal government of Victoria has literally abolished common law rights for psychological claims in transport accident.
Well, Don, the bar's been lifted so high that for anyone to get damages, it's going to be very, very difficult.
And for the government to say that the changes are minor, that's totally misleading.
It is misleading.
It's misleading. And Jeff Shaw, by the way, has a lot to answer for. His vote got the vote through in the lower house, Tony. Now, he has a lot to answer for.
Just to give the viewers an update where they're at, they've introduced a bill. The bill's been passed in the lower house and it's gone up to the upper house. And it was passed with a slight majority. In fact, one vote.
A majority of one vote, and that was Jeff Shaw's vote.
John, thanks for coming on the show. After the break, stay tuned. We've got Dr. Serry. Viewers, welcome back to the show. As promised before the break, we're very fortunate tonight to have the services of Dr. Nathan Serry, very eminent consultant psychiatrist in private practice, graduated from Melbourne University in 1979, so he's been around for a long time, and he's also worked on medical panels, private practice, and he's got a lot to do with injured people. Welcome aboard, Dr. Serry.
Thank you very much for having me.
Now, Doctor, you're in the papers recently on the 30th of October in The Age, quoted about these changes being very tough on injured people. Can you tell us in as few words as possible what the main changes are and your concerns about those.
The changes particularly relate to serious injury claims, people who have got what is called a serious mental injury. And what we are concerned about is that the bar seems to have been set extremely high with essentially an arbitrary definition of what a serious mental injury is. We're concerned about that. We feel that there are too many hurdles for people to pass to be able to essentially get appropriate recompense for injuries that are sustained in transport vehicle, in motor vehicle accidents.
Don, you're a practicing lawyer in this area. You run a transport accident department in your law firm.
Yes.
Tell us some of the hurdles that you've got to overcome. You've got the 3-year wait, haven't you?
That's right. So for the viewers, to access compensation in Victoria, so your right to sue for damages and income loss, you have to have a serious injury. And the definition of a serious injury, which is changing for people who've sustained psychiatric impairment, includes, and I'll go through it, we've done it in the last show, Tony, but I think it's quite important we go through it. The changes that the government wants to make is that for a person who has had a serious long-term mental, severe long-term behavioural disturbance, if that person, for a continuous period of at least 3 years, A, has a recognised mental illness or disorder, B, displays symptoms and consequent disability that have not responded or have substantially failed to respond to known effective clinical treatments provided by a registered mental health professional who is registered under the Health Practitioners Regulation National Law to Practice, and C, has severely impaired function with symptoms causing clinically significant distress and severe impairments in relationships and social and vocational functioning.
Doc, can I go to you? Now, you need someone that's going to have treatment for 3 years. Is that the norm? Do you see people that need treatment all the time, or is there periods where they're probably feeling a bit better and they stop the treatment, then they come back again?
Look, I think that there are so many variations within the clinical spectrum of people who we see. We see that there are people who have difficulty accessing treatment, for example, people who live in rural or remote areas. There are people who are negatively disposed towards seeking treatment for one reason or another. They're uncomfortable seeing a psychologist or a psychiatrist, a mental health professional. We see all sorts of reasons why people may not be continuing to have treatment. We see people who are by and large managed by general practitioners. GPs are not essentially included in this definition. They don't come under this sort of arbitrary definition of a registered mental health professional. There's no such thing as a registered mental health professional.
Doc, based on what you just said now, it's going to put a bigger strain on the resources currently available to people in these situations, don't you think, Don?
Oh, look, I think so. And a lot of GPs, they have a lot of training in this area, don't they, Doctor? They can treat people with psychiatric injuries, and most of them do.
Well, they can and they do, and very often they're the first port of call that people will actually go to. And GPs are frequently working in consultation with other mental health professionals, for example, psychiatrists and psychologists, and they're often carrying the burden of the significant part of the burden of the management of people who are very unwell.
So under this definition, doctor's not a registered mental health practitioner, so therefore they do not satisfy the test if they've been treated by their GP only.
Well, they may not. That would be one of the concerns that we have.
Doc, I've got a serious concern about Part C of the definition. It says you've got to be severely impaired function with symptoms causing clinically significant distress and severe impairment in relationships, social and vocational functioning. In layman's terms, what are they talking about there?
Well, this is almost this is one of the toughest parts of the legislation as we see it. It's the use of the word "and" in between all of those three
So it's
categories.
inclusive.
So it's inclusive.
Yeah.
So one has to have severe impairment in relationships and social functioning and vocational functioning. So what does that say about people who, for example, are not in a relationship? What does that say about people who are the sole breadwinner for their family and against overwhelming odds are heroically going out and continuing to work against all odds because there is no other source of income for their family. To me, it is so harsh, and I can't believe that the government is actually intent on bringing in legislation that discriminates so much against people who, through no fault of their own, are in fact trying to do the best they can under the most difficult of imaginable circumstances.
Do you believe, Don, that the reason for these changes because Victorians or people in general just do not understand what the plight of a severely psychologically / psychiatrically disturbed person is?
Look, I think so, but this definition is a clinical definition, which apparently TAC consulted a chief psychiatrist. This is not a lay person, this is a psychiatrist, chief psychiatrist, who came up with this definition. So, look, the way I see it is like, this is going to penalise people who's stoic. If they're stoic people go back to work, then they don't satisfy this definition, don't have access. Your retirees, your stay-at-home mums, even children. I mean, that's the way I'm reading this. And look, I think this just goes to show that Victoria's got a long, long way to go to really start understanding how psychiatrically impaired people are affected by these things.
Yeah, well, my concern also, Doc, is it excludes a lot of people, doesn't it? It excludes children because they're not working. It excludes retirees because they've stopped working. So it's going to pick up a very small number of people. And you'd think it's going to pick up the most severely disturbed or psychiatrically affected people in society, which are probably getting compensation is not going to help them anyway, I would have thought, because I don't even know if they'll be able to use the money.
Well, and there's another point, and I think that people, when they come to understand just how restrictive this legislation is, often people lose hope. People who are severely injured in any form, whether it's a workplace, in a transport accident type situation, they often need something which enables them to retain a sense of hope. The fact that the bar is set so high and that there are so many exclusionary criteria here, it seems to me as though a lot of the people, and I think of countless of people who I've seen over the years, who would be essentially demoralised by facing these sorts of hurdles and burdens that were not previously there for them.
So, Doc, if I go to one of my clients and say, look, unfortunately, because of how the government has worded this type of injury, you're not entitled to compensation, so apologise, can't do anything for you, that's not going to help them. That will probably make it even worse.
Well, it invalidates much of what they've gone through. And as we know so well, in all sorts of clinical situations, people want to be able to be validated. And again, I come back to my point, I can't believe that the government would actually be promoting a legislation that invalidated the legitimate concerns of large numbers of people. And I think of so many patients who I've seen over the years, this is really concerning.
We've got to go to a sponsors break, viewers, so please stay tuned. We'll take up the discussion just after the break. Welcome back to the show. We're discussing these very important changes to the Transport Accident Act, and that's on the back of the Transport Accident Commission making a whopping profit of just under $1 billion and the state government receiving a dividend of $176 million. So it's really hard to understand, Doctor, why the changes have gone through. The TAC are alarmed at the increase in number of nervous shock claims, for example. They had about 90 last year. What do you say about that?
I can't really say terribly much about the nature of nervous shock because essentially that's a legal term and not a medical or psychiatric term. I think that at issue here is that some of the people who are most severely damaged from involvement in or exposure to such accidents are potentially going to be excluded from being able to pursue appropriate legal redress.
Doc, in particular, there's been alarm raised by the Ambulance Employees of Australia, United Firefighters Union, the Police Association. So it picks up all the emergency services. Is that the people you're referring to now?
Well, often I see in a clinical context emergency service workers who are recurrently exposed to traumatic incidents in the course of their work. So they arrive after the event and they're exposed to carnage, and not infrequently these people develop a condition which can be a full-blown post-traumatic stress disorder or an anxiety, depressive condition with features of traumatisation directly related to the exposure to such events, to the aftermath of such events. So if these people are excluded from the Act by virtue of these changes, that's a source of concern as well, because we know that just working in that area is in fact a risk factor given the very nature of the things that people are exposed to.
Don, the definition doesn't include anyone that's not at the scene, is that correct?
Doesn't include anyone. There is another amendment part of these changes, is that you effectively cannot sue someone who's injured themselves. Let's say the ambulance officers attend a suicide scene from someone who's killed themselves driving a vehicle, that ambulance officer is prohibited from, even though sustained a mental injury, but has not witnessed the accident, just the aftermath, they cannot sue and they're excluded under the Act. So it spreads a very wide net as to the amount of people that get caught from this definition. And one thing, Doctor, I was looking at is, it says a recognised mental illness. So who has to say this is a mental illness? That's a very wide word to use. So are we talking about, does this have to be recognised by the courts as being a recognised mental illness? Is a psychiatrist? Who decides what is the mental illness and if it's recognised?
Well, it's difficult to know what that actually means. It's not a term that we would use in clinical practice. I'm not sure whether the aim of this is to have diagnostic considerations, for example, as used in the DSM-5, the Diagnostic and Statistical Manual of Mental Disorders, whether someone has to meet all of the criteria within the categories or within a particular diagnostic category. It's difficult. I'm not clear about that at all.
And Doc, part of that definition says in brackets, other than abnormal illness behaviour, close brackets. What's abnormal illness behaviour?
We could have a whole series of shows on that, I guess. But whenever somebody becomes unwell, we know that there are certain ways that people behave when they are ill. There are expected ways of behaving. There are certain rights which people develop when they become unwell. For example, often they don't have to work. They have the right to be looked after, to be receiving appropriate care. And there are also responsibilities that come with being unwell, and that is that you've got to assist those who are trying to look after you. You've got to try and get yourself well. The term abnormal illness behaviour is a descriptive term which tries to include those people who don't fit in the normal range of behaviours that one would see when someone is unwell. And there is no firm guidelines for abnormal illness behaviour. It's not a diagnosis per se. It is a descriptive term which covers a wide range of behaviours which essentially don't fit in with what would be expected in terms of the normal responses to the development of an illness or injury.
Doc and Don, do you believe that the word means people that are exaggerating effectively?
Look, my interpretation is that yes. It sounds like it's not a diagnostic condition, so what could it be? It's just someone who over-exaggerates. But Doctor, someone who has these, let's say, abnormal illness behaviour, still might have a psychiatric condition underlying all that anyway.
Very often they do have, and we know that there are vast cultural differences and personality differences in the way that people respond to illness or injury. Some people, you mentioned people who are of a stoic nature, they may not complain, and they may not complain to an extent which is in itself pathological. Tough farmers, for example, who have to get back onto the land and who don't want to complain about anything. They may be seriously unwell, but not complaining. On the other hand, you might get people who have what to any ordinary set of assessment criteria don't have a lot wrong with them that one can see with the naked eye, but the nature of their personality is that they are distressed by such things and they complain vociferously, they complain loudly. Now, are you going to call those people abnormal illness behaviour, or is that just a
Very
normal
expressive
variation?
people. Very expressive people. Don, if someone's in this situation, what should they do? Should they...
Tony, you should be contacting a lawyer. You need to discuss your rights and obligations that you have. The laws have changed. The laws will change, so get advice straight away.
And I reckon this is a great opportunity to give me your Facebook comments, because it excludes a lot of people out there. Firefighters, the emergency services, the people that are retired, it excludes children. It probably only picks up workers that cannot work.
This is very concerning for people who have been injured, and I think this is essentially going to reinforce a level of distress.
And Doc, do your colleagues, the ones you're in constant contact with, share your views on this?
I think this is a broadly held view amongst psychiatrists. Most of my contact is with psychiatrists, but I know that the Australian Psychological Society feels the same way. The College of Psychiatrists, the Victorian branch of the College of Psychiatrists, the psychiatrists who work in the medico-legal area. This is a very broadly held view.
Now, Doctor, you deal with TAC. You do a lot of what we call medico-legal work. You go to the courts. You see what's out there. Not once did the government consult you or your colleagues who do this work to see what change should be made.
My understanding is that there was no consultation with the College of Psychiatrists, with the Australian Medical Association, with the medico-legal group of psychiatrists. There has been some consultation subsequent to the introduction of the legislation, but there was, as far as I'm aware, there was no consultation with any of those groups or with the Australian Psychological Society prior to this legislation being introduced.
And Donald, we've come to the end of the show. We're going to have to take this up in a future, viewers, because it's a very, very interesting topic. Who knows, it might even influence the next election, which is not far away. I mean, Kennett government lost the election in 1997, and I would have thought that the old workers' comp laws had a bit to do with it, Don, eliminating common law. Dr. Serry, thank you very much for coming on board. We'll have to get you back in the future because it's a very hot topic. And we'll see how the legislation unfolds and how it affects society. And we'll bring you back for another episode. So viewers, please stay tuned. Thanks for watching. Go back to our website and see past episodes. Stay tuned for future episodes. And always remember to stay safe.